Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, if I had assets before marriage, could I lose them in a divorce in Connecticut?
So Connecticut is called an equitable division state when it comes to family law and divorce. It's also referred to as an all property state, or you also hear the phrase kitchen sink jurisdiction. Essentially, that means that everything, including the kitchen sink, as they say, is considered or can be considered by a court in terms of division of property. That includes assets that were brought into the marriage, assets that were acquired during the marriage, or assets that appreciated during the marriage. Equitable does not mean half. It doesn't mean equal. It doesn't mean 50-50. It means what's fair and appropriate under the circumstances. And courts have very broad discretion to decide what is equitable and fair. So parties should understand that if they cannot decide between them how to divide property in a divorce, the court has the power to do that for them. And that applies to even inheritance or premarital assets that were obviously brought into the marriage before the marriage started. And those premarital assets can be considered by the court in deciding how to divide up the entire marital estate. So how does that practically happen? Well, it depends on the circumstances. It depends on what happened with those assets during the course of the marriage. Were those assets commingled, meaning were they joined with other assets that the parties acquired during the marriage? Or were they relied upon in some fashion to the exclusion of other assets during the marriage or other income during the marriage? Were those assets, the premarital assets, utilized to purchase a marital home, or were they used to purchase an investment property that stayed segregated in some fashion? And how long ago was the marital home purchased? At what point during the marriage? How long was the marriage? There are certain factors on division of assets that are going to be considered and applied even when it comes to premarital assets. And those are things like length of the marriage and the causes for the breakdown of the marriage or the cause for the legal separation, the age and the health of the parties, the occupation and the amount and sources of income of the parties, the vocational skills and the employability of the parties, and the liabilities and the needs of the parties, and very importantly, the opportunity for each of the parties for the future acquisition of assets from any source. That's something that a court will look to, and in part of that analysis, the court may look to premarital assets, whether they're segregated in some sort of investment property or whether they exist by way of a trust or something like that. The court can also consider what contribution the spouses made, respectively, in the acquisition or appreciation of assets during the marriage. In other words, a court can decide that one party or the other had more to do with the parties having that particular asset, or more to do with the growth of that particular asset during the marriage. And whether that asset was premarital or from an inheritance, an award of that asset or an equal value of that asset from one party to the other may have something to do with that analysis. So keep in mind that a court could theoretically consider some property to be separate, while considering the appreciation on that property, the growth of that property during the marriage, to be marital property. And therefore, the court could look to divide the appreciation in some fashion while awarding one party or the other the premarital asset. The short answer is that in Connecticut, nothing is guaranteed in terms of the way a court may decide to divide the assets of a marriage based on the statutory factors, and that even applies to premarital assets. But having an experienced advocate in your corner may help you understand your risks in terms of litigation and more effectively and hopefully more effectively negotiate a fair and appropriate outcome of your case.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.